New Jersey's ban on short-barreled rifles may be facing its biggest courtroom test yet. And if the Bruen test hits this case the way gun owners hope, one of the state's toughest gun laws could be in real danger. Quick question before we continue, are you subscribed? Because what I'm about to explain could help you understand a gun law fight that may affect what people can legally own in New Jersey. Hit that button now. Here's what just happened. A case filed in federal court in New Jersey is now taking direct aim at the state's short-barreled rifle ban. The plaintiffs include Firearms Policy Coalition and several individual and business plaintiffs, and the case is called Firearms Policy Coalition, Incorporated versus Platkin and Callahan. Case number 3:25-CV-13522. In February 2026, the plaintiffs filed a summary judgment brief asking the court to rule in their favor without a full trial. That is a big deal. It means they are telling the judge, the law and the history are already clear enough. You can decide this now. If you're new to this topic, let me make it simple. A short-barreled rifle, often called an SBR, is basically a rifle with a shorter barrel or shorter overall length than normal legal standards allow. New Jersey bans them. The people challenging the law say that ban breaks the Second Amendment, and they are using the Supreme Court's Bruen decision as the main weapon against it. Now, this is where it gets interesting. Most people think gun cases turn on one question. Does the state have a good reason? But after Bruen, that is not supposed to be the main question anymore. The Supreme Court said courts must first ask whether the Second Amendment's plain text covers the conduct. If it does, the government must show that its modern law matches the nation's historical tradition of firearm regulation. In plain English, the state cannot just say, "We think this is safer." It has to show a real history of similar restrictions from the right time period. And that is why this New Jersey case matters so much. The people bringing the case are not only saying the ban is unfair, they are saying the state cannot pass Bruen's history test at all. If that argument works, this is not just a small change around the edges. This could hit the heart of the ban. First, let me explain why Bruen changed the game so much. Before Bruen, a lot of lower courts used a balancing test. They often asked whether a gun law served an important government goal, like safety, and whether the burden on the right was too heavy. But the Supreme Court said that kind of balancing is not the right way to judge Second Amendment cases. The court said the right is already part of the Constitution, so judges are not supposed to reweigh it like a policy debate every time. That point is huge for you to understand, because once you remove that balancing test, the state loses one of its favorite arguments. It cannot just stand up and say, "This ban helps public safety, so it should survive." Under Bruen, history becomes the center of the fight. The official question becomes this: is there a well-established historical tradition of banning this kind of arm? The plaintiffs in the New Jersey case say the answer is no. Their brief says short-barreled rifles are still arms under the Second Amendment. They describe them as ordinary rifles in a more compact form. That matters, because if the item is an arm, then the right is at least on the table. Then the burden shifts to the state. Here's the part nobody's talking about enough. The brief does not just say New Jersey lacks a perfect match in history. It says there is no founding-era or Reconstruction-era tradition of banning rifles based on barrel length or overall length at all. Not one. The brief points to old firearm types and says shorter long guns and similar designs existed long before modern laws. It also says the first federal barrel length restriction did not arrive until 1934. That date matters because Bruen focuses on the historical understanding around the time of the Second Amendment, and, in many cases, the 14th Amendment. A law showing up in 1934 is very late for a state trying to prove an old tradition. Think about what that means in simple terms. If the state wants to keep a modern ban, it needs old examples that are close enough to show a real tradition. Not just one weird law, not just a modern trend, a real pattern from the proper historical period. The challengers are saying New Jersey does not have that pattern here. Let me give you a hypothetical example to explain this. Imagine your state banned blue pickup trucks tomorrow. Then the state went to court and said, well, we think blue trucks are risky. A judge under the Bruen framework would not just ask whether that reason sounds good. The judge would ask whether there is a real historical tradition of banning that kind of thing. If there is no history, the ban has a major problem. That is basically what is happening here. Except now we are talking about firearms and constitutional rights. There is another big point in the plaintiff's brief that could matter a lot. They say more than 870,000 SBRs were registered as of 2024. Why bring that up? Because gun cases often turn on whether an arm is in common use. If a weapon is common among law-abiding people for lawful purposes, that can make it harder for a state to treat it like some rare outlier. So the plaintiffs are trying to show the court that SBRs are not some tiny fringe item that almost nobody owns. They are arguing these firearms are common enough that a total ban is much harder to defend. That could become one of the most important pressure points in the whole case. Because if a judge starts viewing SBRs as common arms instead of strange exceptions, the state's argument gets harder. And if the history is weak on top of that, the ban starts to look even more vulnerable. If you're finding this helpful, imagine what you'll learn in my next video about the exact words to use when a gun law update leaves you confused during a traffic stop or range check. Subscribe so you don't miss it. Now let me break down why this fight is bigger than just one type of rifle. A lot of people hear short-barreled rifle and think this is some niche issue that only affects a few collectors. That is the first mistake. The real fight is over the legal test. If New Jersey loses because it cannot show a matching historical tradition, that result could reach far beyond SBRs. It would send a message about how courts should handle other modern gun bans too. That is why both sides have so much riding on this. For gun rights groups, this case is a chance to push Bruen into a very direct ban case. Not a permit delay case, not a paperwork case, a straight ban. For the state, the risk is obvious. If the judge says the history is missing, the state could lose the power to enforce this law against ordinary people going forward. And here is where many viewers get tripped up. They think, if the law is under attack, does that mean I can ignore it right now? No, absolutely not. This is a live legal challenge, not a free pass. Until a court actually blocks enforcement or strikes the law down, the law is still the law. Don't make this mistake. Watching a lawsuit is not the same as winning a lawsuit. Now, quick legal note, this is educational information, not legal advice. Always consult an attorney for your specific situation. That disclaimer matters here more than usual because gun laws can crush people who act too early. Imagine you live in New Jersey and you hear a headline that says, "The ban is under threat." If you take that to mean it's legal now, you could put yourself in serious legal trouble. The smarter move is to understand the case, watch the rulings, and wait for real legal change. So what exactly are the plaintiffs asking for? They want the judge to declare the SBR ban unconstitutional. They also want an injunction, which is a court order stopping the state from enforcing it. That is not a small request. That is a direct attempt to shut the ban down. If they win on summary judgment, it would mean the court agrees the law fails as a matter of law based on the Constitution and the history already in the record. But here's the crazy part. Even if the challengers win at one stage, that does not always end the story. The state can appeal, the case can move higher, a stay can happen, enforcement can pause, then resume, then pause again, depending on what the courts do. So if you follow gun law, you have to train yourself to think in steps. Filing is one step, ruling is another, appeal is another, final outcome is another. That's why careful channels matter in this space. A lot of people online will scream, "Huge win," or "It's over," after one court filing. But a filing is not the same as a decision. A motion is not the same as a victory. A district court ruling is not always the final word. You need to understand where the case actually sits, not just what the loudest headline says. Now let's talk about why the history issue is such a headache for states in cases like this. Bruen says constitutional rights are enshrined with the scope they were understood to have when the people adopted them. That line hits hard. It means modern lawmakers do not get to redraw the right just because they think a certain gun is more troubling. They have to connect what they are doing now to a genuine historical tradition. And according to the plaintiffs, New Jersey cannot do that with barrel-length bans. That does not mean the state has no arguments at all. The state will still fight. It may try to point to older cases, older weapon rules, or broader public safety logic. But Bruen makes that road harder because it rejects open-ended interest balancing. So the state cannot simply say, "Trust us, this is safer." It has to do real historical work. And in this case, that may be the problem. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the viewers who want these gun law updates before the headlines get twisted. Click subscribe. Let me show you why this matters in the real world. Say you are a lawful gun owner in New Jersey. You follow the rules. You read updates. You try to stay out of trouble. You might look at this case and think it has nothing to do with you unless you wanted an SBR. But that is too narrow. This case tells you how courts may treat whole classes of gun bans after Bruen. If courts start demanding tighter historical proof, some state gun laws may get much harder to defend. If courts let broad bans survive anyway, that tells you something too. Here's a second real-world angle. Gun shops and manufacturers watch cases like this very closely. Why? Because if a ban falls, inventory rules, compliance plans, customer questions, and business choices can all change fast. That does not mean stores can act before the law changes. It means they have to be ready if it does. And there's a third angle that matters just as much. Prosecutors and defense lawyers watch these cases because constitutional challenges can affect active charges and future cases. If a law gets blocked or struck down, the ripple effects can move in several directions. Again, that does not automatically erase every past case, but it can change the legal field in a serious way. When I found this out, what stood out most was how direct the plaintiff's argument is. They are not asking for a tiny exception. They are not asking for a special permit route. They are saying the whole ban fails the Supreme Court's test because the state lacks the historical tradition Bruen requires. That is a much bolder claim than many people realize. Most people think the toughest part of a gun case is proving the law feels unfair. But the truth is, the more important fight is often proving the state cannot anchor that law in the right history. That is why this case could matter far beyond New Jersey. It is testing whether Bruen has real teeth when a state bans a whole category of firearms possession. So what should you watch next? First, watch for the district court's ruling on summary judgment. That will tell you whether the judge thinks the ban can survive Bruen on the existing record. Second, watch whether either side appeals. Third, watch whether any court order changes enforcement while the case continues. Those are the moments that matter, not random social media rumors. And please remember this, a case being under major threat is not the same as a guaranteed win. Courts can surprise everyone. Judges can read history differently. Appellate courts can step in. That is why good legal coverage needs both energy and discipline. You can say the threat is serious without pretending the result is already locked. This information can change fast with one court order or one appeal. Subscribe now, because my next video will explain exactly how to track gun law cases without falling for bad headlines or fake legal wins. So here's the bottom line. New Jersey's SBR ban is facing a serious constitutional challenge in federal court. The challengers are leaning hard on Bruen, arguing that short-barreled rifles are protected arms, that the state cannot show a real historical tradition of banning them, and that the ban should be struck down. If that argument wins, the impact could go way beyond one firearm category. If you want clear updates without the panic and noise, hit subscribe right now. Like this video if you want more breakdowns like this. And if you've ever wondered whether Bruen would really threaten state gun bans, drop a comment and tell me what part of this case surprised you most. One last simple disclaimer. Laws can change and court cases move in stages. So do not use this video as personal legal advice. Use it as a map, stay updated, and talk to a real attorney if your own rights or your own case are on the line.